I'm Anna and I'm a solicitor in the Medical Negligence Department at Moorish Solicitors. Medical negligence is a term used to describe a situation where a person may have suffered injury as a result of medical treatment that they've received. For example, that could include a situation where somebody has had a surgical procedure which may have gone wrong, or somebody may not have had the expected outcome that they wanted following a procedure. As a starting point for an individual who thinks that they may have a claim for medical negligence, what I would advise that person do first of all is to make a formal complaint to the hospital or the GP practice involved. That's a useful tool for obtaining the hospital's version of events. There's a lot of information to consider, but very often an individual will get answers to questions that they want answering. We can then use that to help assess. That response that you get will help assess whether you have a claim or not, and it's something that we can help you with at Moorish. We can help you write that complaint and guide you through that process. In order to succeed in a claim for compensation for medical negligence, you have to prove two things: something called breach of duty of care and something called causation. What that means is you've got to be able to establish that the standard of care that you received from the individual doctor or medical professional fell below what we call a reasonable standard of care, and the causation element that you've suffered some injury as a result of that breach of duty. Medical negligence is quite a complex area of law, and it's important that you obtain advice from a solicitor with experience. They may be on an accredited panel, but as long as they have that experience and expertise to guide you through the process from beginning to end. In order to investigate your claim, we would obtain copies of your relevant medical notes and records. We would then instruct an independent medical expert to examine those records and prepare a report dealing with the legal test of breach of duty and causation in order to establish whether you have a claim or not. If we obtain a supportive report from the expert, it then may be necessary for you to go and see that expert for an examination, and then we can obtain a further report dealing with the effects that the negligence has had on you. There are strict time limits within which you have to pursue a claim for medical negligence. You have 3 years from the date of which you knew or ought to have known that you suffered injury as a result of the negligence. So my advice to anybody would be to contact a solicitor as soon as possible when you think that you may have a claim. Understandably, an individual might be concerned about pursuing a claim because of the potential costs involved, because of the complex nature of the type of area of law and what is involved in the investigation process. There are a number of different funding options available to an individual dependent upon their individual circumstances, and that's something that the solicitor will discuss in detail with you to reassure you. For example, we may be able to offer something called a no-win, no-fee agreement, or in certain circumstances your case may be suitable for legal aid funding. It's very difficult to say with any certainty how long a specific case may take to conclude. Depends upon the issues involved, the complexity of the injuries that an individual has suffered, whether the hospital or the doctor concerned accepts responsibility for those injuries. But what I would say is that your solicitor will keep you updated every step of the way.